Gentlemen, I'm absolutely delighted to welcome Gavin Roberts, who's going to talk to us about the quantum guidelines. Gavin is a personal injury attorney of renown, very well known up in the Gauteng area, and I would say nationally. He is now with Roberts and Associates Attorneys, personal injury attorneys, and he is also the Chief Legal Officer of Funda Medical, which he has been for some time, but he continues with his role at Funda Medical. Gavin's got a wealth of information on the actual practicalities of dealing with personal injury claims and in particular quantifying those personal injury claims. So I'm going to be very, very interested, Gavin, to hear what you've got to say about this book. But welcome. It's a real honor and a privilege to welcome you to this launch of the quantum guidelines, Gavin.
Thank you, Ian. Very detailed and an ego-boosting introduction. Thank you for that. Yeah, I've been around the block a few times, and as have you. And I could say the same for you. You know, I think we've had many conversations over the last year or so with your involvement in the medico-legal industry, in the legal industry, and I think your reputation speaks for itself. You know, you mentioned the name Ian Dutton around the Durban circles, and all the attorneys know exactly who we're talking about there. That being said,
thank you very much, Gavin. That's very kind of you, and I appreciate that. Yeah, and I just want to say that, you know, you mentioned those conversations. I want to just thank you and everyone at Fundamed as well. There's sections of this book, and we'll probably get into them, but in particular the narrative test and then also the assessment of injuries, where, you know, those sort of background conversations really inform the approach which you take to a book like this, because you want to make it theoretically sound but practically relevant.
Yes, absolutely. And I think the one takeaway, if I could kick off with the wealth of information in your guide, the takeaway that I would have is the user friendliness of this guide, giving a wealth of knowledge to not only attorneys but to experts alike. So if you look how you outline the process, the entire claim process, in a very, very short, succinct, and very nice detail, but backing it up with case law, the relevant authority, which I think is very much lacking in our industry. So I think that if you look at the target market that I would say would really benefit from this, it's not only one specific niche section of the personal injury game. It's going to benefit all attorneys, from newly admitted attorneys, newly functioning attorneys in a new practice, helping them to know what is going to qualify, what's not going to qualify, how do I go about the process, right up to the seasoned campaigners in quantifying the claim and actually saying, how can I challenge the current mindset? And you mentioned earlier about the narrative test, and you know, just for brevity, you know, my daughter's obviously an expert. She's a psychologist. So we have many debates and arguments. And I think the biggest argument we've had over the last year revolves around the narrative test. And if there's any sort of glitch or any sort of, Afrikaans referred to a leemte, a sort of a gap in this entire personal injury market, it comes to the understanding and the application of the narrative test. And why is it critical? And I've been hounding this, and when I went through your guide, it is so nicely set out. I actually can't wait for this to come out, that we can pitch this to the experts out there and to the attorneys that are requesting these narrative tests or sending your client to for a medico-legal assessment, and then saying, well, I don't have the 30% WPI, what happens next? And seeing the drivel that is being put out into the industry, in direct contravention of how this thing should be happening. This book is revelationary in that regard. And obviously, you know, someone like myself that goes and researches a lot of case law and that in quantification, your assessment tables are fantastic, you know, with current values, case law. So the absolute thread of case law all the way through in everything that you speak about, from something menial about the delict function of a road accident fund claim or a personal injury claim, all the way through to the assessment, to the narrative, quantification, and then the court's hand-on approach. I think that is gold. You know, a lot of attorneys will say, well, this is my take on it. Yes, but how are the courts interpreting this? And I think that is gonna benefit legal practitioners really, really well. It's a really, I'm surprised you fit all of this into the number of pages that you did. And, you know, but the language is not convoluted. It's very modern in terms of how you've translated it and how it's been put down on paper. And it's not convoluted that somebody's going to look at it and say, what is this legal terminology? I don't understand this. So it caters for everyone across the board. And I think it's going to be an excellent reference. I actually want to liken it to, every personal injury attorney has the Klopper book at hand to understand, it's sort of been, and I say this reverently, the Bible for RAF practitioners over the years. I absolutely can tell you that this going forward will definitely be for anybody in the RAF game specifically, and personal injury game is going to be really revelation to you. And it's going to be that sort of thing you want on hand all the time when you're going forward and negotiating and settling your claims.
Yeah, I'm very pleased to hear all this, Gavin, because that's, I mean, we didn't discuss this before, but that is, I could almost take a template of what I set out to do and now what you're reflecting back. I mean, I've been in practice now for 30 years, an attorney, as an advocate, and I know what preparing cases is. I know you want to get to the point, you want to get it quickly, and you want it clear language, but you also want the reference to authority. So what we've done is we've tried to get it succinct, and that does take a lot of work to get it into those simple terms. It's deceptive. There's an article by Harams on appellate advocacy, and he says, he says that brevity is hard work. It's words to that effect. Very true. So I'm delighted to hear that, Gavin. And the other thing that I'll add to it is that the landscape evolves very quickly. So one thing that I would just add to that is that this is the textbook, but we don't want to just leave it at the textbook. We've got current awareness that we're going to bring out on the quantum guidelines, and then a sister sort of current awareness on personal injury principles, which is a subscription-based product, but that will then bring things up to date on a sort of weekly basis. And you'll see the way the structure of the book is that we've got paragraph numbering, and then where a case deals with a principle, we'll insert it into that paragraph numbering to keep things current. So I'm very excited about this work going forward. It's actually been a labor of love to draft this thing, because I've dealt with it over the years, but it's very nice then to get the whole big picture and put it all together. So I've thoroughly enjoyed it.
Yes. I think what's very relevant to how you've actually put this onto paper, Ian, is if you look at what the RAF Act prescribes and what's happening in practice, there's a vast difference. And I was speaking to a law student the other day that's a third-year law student and was actually doing the law of damages model. And they said, what they had to write in the exam when they were tested on how the road accident fund claim process works. If they had to write there how it actually works, they wouldn't have scored anything. So I think there's a serious disconnect at the Road Accident Fund, because earlier years, and I mean this is going to highlight the point. Earlier years, if you wanted to be a claims handler at the fund, you had to be a law graduate. You had to be somebody that had legal knowledge. Now they rely on Dr. Google, right? So I mean, I've sat in block consultations with RAF where they'll say, what are your client's injuries? And I think he's busy adding it. He's busy typing. He's busy adding it into some sort of executive summary. In the meantime, he's Googling a femur fracture, compound femur fracture prognosis. And if the prognosis, according to what Google tells him, is good, then he's saying, well, then I'm going to refer for GDs. And, that's always been sort of a conundrum for me. And what is really, really relevant in this whole process is an attorney that's now looking at this and how it's working. How do I know from the onset whether I should I take this mandate? I'm going to expend a lot of time, effort, money, and a big portion of my life over the next couple of years in finalizing this claim. Is this going to be viable? And if I tell you how many people have approached that have come through the Funda medical channels and approached me directly and to say, when you sit with a client in front of you, how do you know if this claim is going to qualify or not? And this may be something that we can add a little meat to in your further updates to the manual. But your manual as it is here now already gives very clear guides onto what will qualify, what should qualify, what won't qualify. And it's easy to say, here's the list, and I see you have it in your guide, the injuries that the fund so graciously posted and said, these injuries don't qualify. So let's start on the negative. These don't qualify, but everything else, give it a bash. I think your manual is very, very clear cut on what will qualify, because if you look at the statistics, what percentage of claims actually qualifies over 30% in terms of WPI? It's a very small ratio compared to the amount of claims that are lodged. So there's a huge reliance on the narrative test. Now, in the narrative test, what does the attorney do? They have to rely on the medical expert. But with no literature out there and the AMA guides being pretty much silent on how it should be completed, there was an article published by the HPCSA on how to complete the narrative, but it just says do this, do this, do this. Rely on the functional reports, but your breakdown of that in terms of the impairment and the disability, etc., is it's revelationary. I can tell you, it's gonna really highlight to people and to practitioners and the medical fraternity out there how things should be done in terms of a narrative. If I see one more where a client goes to a medical practitioner and they send back, this is the standard wording, the client won't qualify for a narrative. Now, the wording already is a problem, right? Everyone will qualify for a narrative. You may not qualify on the narrative, but it's like saying when you turn 18, you don't qualify to go for your driver's license. You at least get the option that you must be tested. So, and highlighting the processes that must follow. So your manual, I'm really, really keen. I've made a million notes on your draft copy. I promise that I will purchase a proper copy, but your draft copy, I made a million notes on there. And it's really been an excellent read over the last couple of days.
All right, Gavin. No, thank you very much. Just on a technical point, and then I'll wrap up. But just on that narrative testing, of course, that 30% WPI is high by international standards, and of course, that's why really the main motivating factor why we've got the narrative test in the first place. And I think if I can just say on a technical note for people assessing in terms of the narrative test, bear that in mind, that is built into our system, that we've got a high benchmark to qualify for GDs or non-patrimonial loss, but they mustn't be shy to use the narrative test. It's there for a specific reason, to fill that particular void. So and then Gavin, just the other thing, just following on from what you've said, we see this very much as a start point, not an end point. And we work very closely, as you know, is a great example actually of someone that we work closely with. We get tremendous feedback from you and from other practitioners to guide us in the way. The real sort of challenge for us is to take that theoretical knowledge, give a sound theoretical knowledge basis, and then fit it into, so that it fits into practice. It's not just some abstract theory. It's actually there in the way that it's presented, in the type of knowledge and the quality of information that the practitioner can go forward and apply it easily. And we will develop that over the next few years. I see this, as I say, as a starting point, and we will get this work and the related works better and better, so it fits closer and closer with what ultimately the who needs to be satisfied is the practitioners, and I include their judges and mediators as well, I should mention, and of course attorneys, advocates, and expert witnesses. So we will work hard at making that fit very tight. Gavin, listen, any concluding remarks that you want to make?
I think your expertise in the field has come through very nicely and very clearly in your guides. And one of the things that you do touch on as well that I'm quite passionate about, where the shortfall is with many litigation attorneys at the moment, personal injury attorneys, is the aspect of contingencies. Now, if you look at in your damages that are awarded, the specific head of damage for future loss of earnings, loss of earning capacity, makes up the vast majority of a road accident fund claim. So that's quantum wise. So attorneys don't understand this, and you see how often somebody will just come and jockey around, well, let's just adapt the pre and post morbids and let's get close to the number that we want. So they fiddle with the contingencies to get to the number instead of actually applying the contingencies correctly. And I have to tell you, I've attended many lectures that we pitched for attorneys to say, this is what contingencies are about, and attorneys do not understand contingencies. You've given such a great, clear rundown of what contingencies are in your guide as well. And I can't tell you enough that the market that you're going to cater for, this is like your other works that you've produced are pretty much based on the Medico, that's pretty much focused on the medico-legal expert, and it's for good reading for the attorney, but not of major relevance because it's more applicable there. This guide would be applicable to everyone across the board. So I think it's an all-encompassing, very detailed and informative guide. And I have to congratulate you. When I started reading, I thought it was just going to be something aimed at the attorneys. We'll use the quantum guides, et cetera, but then you still got to read up on the case and that. But having a breakdown of specific injuries and what you can claim for in relation to what your quantum is based on that, I think this is worth gold, absolute gold. And I really want to congratulate you in how you've put this together. And I can't wait for updates as they go along, because as you said, it's an ever-changing landscape. Just look at the number of directives that have been implemented in Johannesburg Court alone, in terms of this. And that's not to mention the different regions. It's quite psychedelic, even though it's a national footprint with the Road Accident Fund. But yeah, I'm really looking forward to this and the launch of this guide, and to see the reaction of everyone out there. I think it's going to really be revelation for everyone.
Gavin, I couldn't thank you more. Thank you for your kind words, for all your support. And I think probably the most important thing for all your input, as you say, over the past just about a year and a half now, actually, Gavin, I think. But anyway, listen, for all your intellectual input and your I mean, you talk about me having expertise and knowledge, your insight and experience from every facet as a personal injury litigator and more broadly dealing with expert witnesses. So thank you very much for your time and making the time for me. I know how busy you are and I appreciate it. And all the best in your ventures and where you're going forward. And I'm sure we'll have a lot of interaction over the next few years. Thanks so much, Gavin.
Thank you, and looking forward to that. Have a great
Lovely.
one.
Okay, right. Thanks a lot. Cheers in. Bye-bye.
Thank you, man.